This is a divorce case that was finalized on April 23rd, 2023, out of Smith County with Judge Clara Bird acting as the presiding judge. At the time of the divorce, Ms. Cowan was 60 years old, Mr. Cowan was 59 years old. At the time of the trial, the parties had been married for a period of 16 years. The issues on appeal that we're presenting are issues related to the equitable division, the alimony award, and the attorney fees incurred on appeal. I want to start with the equitable division and very specifically the way the court divided the cattle owned by the parties at the time of the divorce. So at the offset, I do want to make it really clear that there were 36 heads of cattle altogether. The court did identify all of those during the trial, and the court also did value all of those at the time of the trial. In the final decree, though, she only specifically awards 8 of those cattle. So the named cattle, so the cows that actually had names to them, she awarded to the husband because he had an emotional attachment to them. So the problem we have here is no matter what, she just doesn't address the other 28 cattle. It's presumed that she meant for the husband to be awarded those because of how she did divide the value, but she didn't name those cattle to be awarded to the husband. We also have here a situation where the court, Judge Bird, she valued all of the cattle. It came to about $32,000 for the total value, so about $16,000 would be half the value. Instead of saying, I'm going to offset that, provide the wife with an extra $16,000, she said that the husband's going to pay the wife $666.67 per month for a period of 7 years. So in doing that, the court's not really considering the actual value of the cattle at the time of trial. She's speculating that he's going to be able to keep turning a profit of about $1,300 a month for 7 years into the future. And a big problem with that is that she also, the farm itself, was awarded to the husband, and he had the option to refinance it and pay wife her share, or he was to sell it. But there was no provision for what would happen with the cattle if he was to sell the real property. Obviously, if he sells his farm, it's going to be really tough for him to keep going in the cattle business for 7 more years. So there wasn't a way or a method left open for the husband to come back into court and modify this monthly obligation to the wife for just cattle sales. So it's not like alimony in futuro, where presumably if there's a material change in circumstance, he could come back in and ask to modify the obligation. I mean, it seems to me, no matter what happens to husband, if he has to sell the property, or if he had some kind of medical condition arise, he'd already had 5 bypass surgeries, he had broken his shoulder, he was 59 years old, he testified he was on several medications. So I think it's very speculative in the first place to assume that this gentleman could keep going in the cattle business for another 7 years. He was already 59 years old. The court has reviewed the exhibits. Exhibit 23 actually contains the trial court's calculations for what these cows are actually worth. So really the prices were, the bulls were $1,500 each, the most expensive, and the other cows were various numbers, but again, the total came to $32,550 for the current value at the time of the trial. The judge went out of her way to handwrite an exhibit with all these calculations, but these numbers never made it into the final decree of divorce. I've run the numbers on what the wife is actually awarded. If you take the sum of $666.67 and you multiply that out times 12 times a year for 7 years, it's about $56,000 she's going to be receiving for the value of the cattle at the time of trial, when in fact she had already done a calculation that said they were worth $32,000. So her half, again, is around $16,000 she should have been awarded for the value of the cattle. And of course, the wife also testified that she had some of her own medical issues, etc. We took issue with how the court really, and this goes for the equitable division and the alimony side of this case, the court didn't go through the statutory factors really at all on the record. Of course, I understand the trial court's not necessarily required to do a detailed analysis of every single factor as set forth in these statutes, especially the equitable division statute. But she did find that the wife contributed to the cattle operation. I don't think there was really any testimony that seemed to indicate she did. some of husband's outside income from his primary job, he would use that, roll that into the cattle business, and he also testified that of the money he did make in the cattle business, of course, that was rolled back into the cattle business. But the wife was not feeding these cattle or making sure they were grazing or anything really related to the operation of the business, and there's nothing in the record to indicate that she was. Another issue, just as far as the cattle goes, he submitted 6 tax returns into evidence, so the 6 tax returns that were closest to the date of trial, so from 2016 up through 2021. And if you look at the actual farm operation part of these tax returns, he's operating at a tremendous loss every year in the cattle operation. Specifically, in 2016, there was a loss of $11,000, 2017, $12,000, 2018, $16,000 loss, then $21,000 loss, then an $18,000 loss, and a $9,000 loss just the year before the trial. So I just don't understand how the court could see this and say, hey, this guy's making a huge profit on this cattle, I'm gonna make him pay her for this for the next 7 years. The trial court also did at one point kind of say, well, I'm surprised that the IRS hasn't classified this as a hobby farm because husband's not really turning a profit. But then, of course, she turned around and made him pay an obligation per month for this cattle. I did a lot of research in this case trying to figure out, okay, what's happened with cattle in the state of Tennessee before. I cited the 2 cases that were examples of how trial courts handled the division of cattle. In both of those cases, the trial court valued them, divided them. There was no monthly obligation. So it's a little unusual. It's a departure from the norm, I would say, to make the husband pay a monthly obligation. What we're requesting the court to do in this specific case is to reverse the trial court's ruling regarding the cattle and to change the ruling to be tacking on the $16,275 of the wife's share of the value of the cattle to what husband already owes the wife for the remainder of the equitable division. So if we were to do that, then husband would have to pay the wife $179,082, and that would equalize the equitable division. As to the issue of alimony, it's actually sort of the same complaint we have with this issue. Again, the trial court didn't go through the statutory alimony factors substantively at all. I don't know if the statute 36.5.121I was even referenced by the trial court. Again, this is a situation where she didn't make the judgment that the wife was the economically disadvantaged spouse, but we don't really know why. So I think it would need to be reconsidered on remand. The amount that he was ordered to pay per month is $600 for a period of 7 years, and this was classified as alimony in futuro, which it's a little unusual to have an alimony in futuro obligation that also has a monthly or a yearly term for 7 years. I'm assuming that amount would be modifiable, but she didn't specifically say that. I don't think the trial court really adequately considered the wife's income and expense statement. She claimed she was paying $300 a month just for laundry and cleaning supplies. She also didn't present evidence to corroborate what her future needs would be. So if you look specifically at the wife's income and expense statement, there's no future rent or future mortgage. It's all based on what the payments were during the marriage. So I don't know how the trial court would have sufficient information to know what the wife anticipated her needs would be in the future. The parties lived in a manufactured home. It was valued at $305,000. If she's awarded $179,000 or $162,000 from the equitable division, it doesn't appear to me that the trial court took that into consideration for alimony. Because I feel like if she gets that much money in cash, $162,000, she should be able to maintain a very comparable lifestyle to what she enjoyed during the marriage. I also don't believe that the trial court took into consideration husband's health to a great degree. The wife testified that she had fibromyalgia, that she'd been diagnosed with it 21 years prior to the trial date. So she had that coming into the marriage, yet she was still working almost full time. What we're asking for alimony here is to reverse the trial court's judgment and to remand it so that the trial court can actually go through the factors in the statute and enter an award that's more appropriate. The other thing the court didn't consider is husband's going to have to pay for health insurance and also medical expenses post-trial because he was on wife's, and she didn't address that at all at the time of trial. I'd like to reserve my remaining time unless there are questions.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Christopher Beauchamp. I represent the appellee in this matter, Miss Vickey Cowan. I am a member of the Wilson County Bar, and I appreciate the opportunity being afforded to me and Mr. Zanitas to come and argue this case. There's really two issues and then one kind of collateral issue that results from us being here in the Court of Appeals that Mr. Zanitas explained fairly well and certainly explained his viewpoint with respect to the trial court's ruling. Certainly don't hold this against Mr. Zanitas because he wasn't trial counsel, but I was trial counsel in this matter and participated in it. And to say that the trial went somewhat unorthodox would be an understatement. For the entire first day, the primary examiner of the parties was Judge Byrd, and she went through and asked all kinds of questions related to the personal property and was making conclusions as she went, and I think that that'll be fleshed out in the transcripts in this. With respect to the cattle business in particular, one of the prevailing issues that Ms. Cowan would take issue with respect to Mr. Zanitas' argument on behalf of Mr. Cowan is this double-dipping theory that he presents on appeal, in that when the court made its equitable division of the personal property, including the farm equipment, that farm equipment, the tractors, the bush hogs, and the various implements that were attached to the farm tractors was utilized by Mr. Cowan in his bush hogging enterprise, of which there was no division of that business interest that Mr. Cowan had. And so the cattle itself is a separate enterprise, and the court made its determination that as a result of the statements that Mr. Cowan testified to, that he wished to continue farming as long as he could, and in his income and expense statement, when he was questioned about the income that he denoted on that related to the cattle, he only included half of that income, with the thought process that the remaining half was being given to Mrs. Cowan. And that is the number that Judge Byrd grasped a hold of when she issued her ruling. Ultimately, reversal of that decision is dependent upon this court finding that Judge Byrd abused her discretion in so ruling. And while Mr. Zanitas points to the two cases in his brief with respect to cattle-related equitable divisions and the trial court making a determination that they would divide the value of the cattle itself as an equitable division, which was affirmed on appeal, while X may be true, the inverse of X isn't necessarily untrue. And so what I mean by that is, just because a court of appeals, in reviewing a particular decision of the trial court, affirms a decision, that doesn't mean that the method by which Judge Byrd allocated future income, in this case to Mrs. Cowan from the cattle enterprise, is contrary to the law.
Well, I noticed that you didn't cite any authority to that effect in your brief, that she had the authority to make a decision like this to award the monthly payments of $666.67 per month.
Yeah.
You didn't cite any cases that supported that.
You're right, Your Honor, and as I'm sure Mr. Zanitas did, I did as exhaustive research as I could to try and find a case on point that would follow similar and would allow for similar decisions in other cases, and I could not avail myself of any. So
I assume you went beyond Tennessee.
Yes.
Maybe because there aren't any.
That's quite possible, Your Honor. So with respect to that particular issue, it would be Ms. Cowan's request of this court to affirm the decision as it relates to the equitable division. As it relates to the alimony, we would concede that Judge Byrd did not make specific factor-related findings in the final decree. She did make findings with respect to the comparative fitness of each of these individuals and their ability to pay, as well as the need of the disadvantaged spouse. She mentioned in her ruling that Ms. Cowan is not able to be rehabilitated, that she's doing everything that she can, and as a result of her autoimmune disorder, her ability to return to school for further education or to increase her income was limited or non-existent. And so as a result of that, and the comparative incomes of the parties in this case, and further, the fact that while the parties were married and even subsequent to the divorce complaint being filed, Mr. Cowan was contributing $300 a week, for the most part, to Ms. Cowan so that she could maintain her status of living and pay the expenses that were necessary for her to continue living in that home. And so with respect to the alimony award, the courts, it would be our position, and we would submit that the court made the right decision with respect to the alimony, and it awarded an appropriate amount, and it selected the appropriate type of alimony.
Is that alimony in futuro?
It is, yes, Your Honor.
When it has a limited time frame?
She called it in futuro, even though it's only for 7 years. She called it in futuro to allow Mr. Cowan the opportunity to modify it depending on his circumstances.
Is that legally supportable?
Arguably, yes.
You didn't cite any cases to support that.
I did not.
You say she called it alimony futuro, so it could be modified at some point during the 7-year period. Did the judge actually say that?
She did, yes.
Okay. But didn't say that in the order itself?
I don't have the order with me. I believe in the order, it was mentioned that it was in futuro alimony.
Right. But with no further mention of why an amount of alimony for a fixed period of time is in futuro rather than transitional.
Yes, that is fair.
Okay.
And lastly, Your Honors, the issue of the attorney's fees. We are here on an appeal that was initiated by Mr. Cowan, and I've cited the law in my brief with respect to attorney's fees, and ultimately would ask the court to consider the evidence that led us to this place where the court made a determination that Mrs. Cowan was the disadvantaged spouse, and quite frankly, her ability to pay any of Mr. Cowan's attorney's fees is limited. On the contrary, by virtue of her having to hire an attorney to represent her in this appeal, and with her limited income, I would submit to the court that if attorney's fees should be shifted in this matter, they should be shifted in her favor. With that, I would ask the court to affirm the decision of the trial court in Smith County, and I will pass the microphone. Thank you.
Thank you for your candor, counsel. You have 3 minutes.
Thank you. I just wanted to briefly address this double dipping argument that I made in this appellant brief. So I think I've already spelled out that the trial court valued all of this farm equipment and then offset that so each party received half the value of the farm equipment. Opposing counsel is arguing that, well, that may be true, but all of the farm equipment was just for bush hogging. That just can't possibly be true. Anyone that runs a cattle operation with, I guess it's 36 cattle, they're going to use some of their farm equipment for things related to those cattle. And I would also note that if you look at these tax returns, if you look at the actual profit and loss from farming, under the principal crop or activity, it says cattle. It doesn't say bush hogging. So I do think that she was awarded half the value for this farm equipment, and I think that does apply to the cattle business too. So on one hand, the trial court is giving her half the value for the farm equipment, but on the other hand, the court's not giving her half the value for the cattle. She's giving her almost double, triple the value of the cattle at the time of trial. So that's how it played out. So on one hand, she's getting a monthly obligation for the cattle. On the other hand, she's getting an actual value for the farm equipment. I don't think those things lined up. I also, as far as the cattle go, I mean, the statute requires that we divide things as close to the date of divorce as possible. These cattle, they're going to be around for a few years, but all 36 of these cattle are not going to be there 7 years from now. So I guess the trial court was anticipating that Mr. Cowan was going to acquire more cattle or have more cattle or breed these cattle. But if he's doing that post-divorce, then that's post-divorce income of just Mr. Cowan. She's not over there helping out with the birth of these calves. So I don't think she should get credit for his future efforts. And I don't think he should be required to keep raising cattle for the next 7 years. As far as the alimony in futuro situation, again, I think I already spelled out, it's just unusual to have a term of 7 years or any term for alimony in futuro. My client's not necessarily arguing that 7 years is insane or crazy or anything, but we would at least like it to be spelled out that this obligation is modifiable in accordance with the statute as far as alimony in futuro goes. So if there is a material change, he has the ability to file a petition to modify.
Do you think this is alimony in futuro?
I think it's definitely justifiable. I mean, it was a 16-year marriage. It's not a short-term marriage. It's not a mid-term marriage. I will note, though, that, I mean, Mr. Cowan was married for 4 times before this marriage came to an end. She was married twice. So these two people have had lifetimes of marriages and everything else going on. So it just fell on him, I guess, at the end that this was the final marriage.
No, my question was, do you think that this is alimony in futuro versus transitional alimony?
I think that was the court's intention was to do alimony in futuro. I just think something unusual happened when she threw out the 7-year duration. I don't know why that happened.
Thank you.
Thank you.
Thank you very much for your argument, counsel. We'll take the matter under advisement and render an opinion as soon as possible. Thank you. I call the next case.
Brett Thomas Ferguson